Yeah.
Because she's from here. She grew up in Deltona. And the connection I have to her is my wife's cousin went to senior prom with her.
Oh, that's so random.
Yeah, that's completely random.
Small world.
Yeah.
Sure, shall they? In her farewell. She's gonna say where she's going.
So I guess she must be like done. Like,
All rise. Circuit Court of the 9th Judicial Circuit for West County, Florida is now open. Freddie J. Lawton, Chief Judge presiding.
Thanks, can I see?
All right, we're on the record in 2016 CF 15738, State of Florida versus Markeith Loyd. Would the attorneys announce their appearances for the record?
Rick Ridgway on behalf of the State of Florida.
Rich Buck on behalf of the state.
Everyone on Ted Barrera, on behalf of Mr. Loyd.
All right, Mr. Lloyd's present in the courtroom. I think today's status involves a series of motions to be heard, and I'm ready to go whenever you are. So do you want to start with, why don't you tell the state which one we're starting with, and then we'll...
Well, Judge, oddly enough, the state is the one that noticed these for hearings today.
Okay.
We could go down the list in that order, but I can tell the court that yesterday I filed a notice of intent to call some experts. Really, the two main death penalty motions are just not right to be heard today. The main one regarding death qualification, and the other one regarding the 8th and 14th Amendment violations, because I think for me to carry my burden, for me to carry my burden on this hearing, I need to present a detailed statistical analysis of the issues involved in both of them, and I'm not prepared to go forward with that.
Let's talk about the motion that that just attacks the death penalty per se, not jury selection,
Right.
and that you, in a sort of a proffer, have expert witnesses that you want to present about the racial disparity in the imposition of the death penalty, which appears to me to have been addressed some time ago by the United States Supreme Court. Do you have experts that you have retained or talked to who will present whatever statistical evidence you want to present or analytical evidence that you want to present?
I have one.
Right.
Well, actually two. I mean, one of them is a statistician, and the other one is a more of a social scientist.
Right. And how long before they would be ready to go on that matter?
I'm not sure, Judge.
It seems to me that this is a settled area of law because there's precedence, but I could understand you wanting to create a record because sometimes settled areas of law become unsettled or they're revisited. And I'm wondering if the prudent course isn't to get that into the record in the most convenient way to you and for it to be preserved. Trying to imagine, having read the Supreme Court case, what you could present where I could rule differently than the established precedent right now. And it's a little hard for me to imagine it. So then I'm wondering, is there just an efficient way to perfect your record so that you can argue? And I don't know, the state might disagree with this whole approach. I'm not sure, where either a report is shared with them and maybe it's stipulated to be in the record, or maybe they want to, thoroughly cross-examine the witness. I don't know that you all probably haven't talked about that, but.
Well, Your Honor, first of all, I think the court's premise that I think this is an established, settled area of the law, that no matter what statistical analysis they present about imposition of death penalty in other cases doesn't meet the burden of showing some racial motivation in seeking the death penalty to Mr. Loyd, which is what they would have to show.
Well, is it that or that the legislature was racially motivated when it adopted the scheme?
Now, either one. If they're attacking the statute as having been racially motivated, then they would have to show that it was enacted with the purpose of making it racially disparate in its application. The second act would be that if the statute is not, but that the application in this case was, that would be the
So it's sort of the facial or as applied attack?
Yes.
Okay.
But the rules are both the same. You can't prove either one with statistics. You have to have some evidence, other evidence. If the experts in question drafted reports that I could review, I very well may agree that they could put their reports in the record, preserve the issue, and move on. Failing that, then obviously I'd want to depose them, see what they had to say, and decide whether I needed to do something more or not.
Well, as there's a sort of a theme that I've repeated, I would like you all as professionals to communicate, because it might be that the most efficient way forward is if your expert writes a report, if you share the report, which I think you'd have to do if there's an evidentiary hearing with Mr. Ridgway and Mr. Buxman, they might say, all right, we'll stipulate to it being in the record, or they might want to depose or cross-examine your witness. So I'm just contemplating what's the most efficient way to proceed given the Supreme Court ruling in the area. And the same thing might be true with respect to jury selection, which once again appears to be a settled area of Florida law. And I don't know if it's the same expert in that area or different experts.
Judge, actually, no, that would be someone else. I don't actually have anyone specifically lined up on that just yet, because there have been studies, and you know, we're in a brand new world regarding this because of it's post-Hearst, so everything's done differently now. And there are ongoing studies. I don't know if any of them are near completion. I just know that you can't rule on the matter without a more up-to-date analysis on it. And you know, it may be as well that submitting a written report would suffice to preserve the matter for appeal, but I'm not even at the point where I can say that just yet. I mean, I think, you know, previous case law from the Supreme Court contemplates the possibility that this could happen.
As an officer of the court, you don't think that this has been ruled on by the Florida Supreme Court that has said that the death qualification of the jury meets constitutional muster, even though I know defense counsel often disagree with that and think the ruling should have been different, but the ruling is the ruling, and it seems to me that it's been ruled on. Now, again, I understand you may want to say post-Hearst or with more modern science or with better statistical analysis. I want to create a record, but it's sort of the same thing that I've talked about in the previous ruling. If you get an expert to the state and then they'll take a look at it, they may say, we can expedite this, we don't have to go through what we sometimes do with experts, which is depots, like the evidentiary hearings, or maybe not, I don't know. But how long do you need to develop that expert?
Judge, unfortunately, it's difficult for me to say.
You don't have someone who's been identified at this point?
I put out a request to try to locate people across the country that are studying the issue and that may at some time be prepared to testify about it. As far as I know, it hasn't happened yet, anywhere.
Okay.
So this would be the first time.
What I'm trying to avoid is, you know, an 11th hour, oh, we've got to stop now and have this hearing. So I just want you to act with as much speed as you can with respect to this. And you might convince me that I should rule differently, but I also understand if you're trying to perfect a record for arguments that you want to make, because we know the laws and it's a developed area, and so I know you want to preserve certain things. But I just, as we get close to trial, I want to get as many of these things resolved as we can. All right, are you ready to talk about your motion for transcription of grand jury proceedings? Okay, let's do that.
Yes, Your Honor. I read the state's response, and the analysis that gets done on this matter has to do with showing of need balanced against the secrecy of the grand jury. Number one, the grand jury is long since closed on this matter, and so the need for secrecy is, I would say, extinct. Because we're looking for the testimony of witnesses that the state has listed as witnesses and who are going to testify in the trial. And so what we want to get from them is completely and totally relevant to our trial and completely necessary for us to be able to cross-examine witnesses and to test their testimony in front of a jury, which is what we're here for. In Dennis versus United States, that was shown to be meeting the requirement of a particularized need. We're not asking for everybody's testimony. We're not asking for a list of every witnesses. We've specified the witnesses whose testimony we want, who, as we said, the state is going to call as witnesses. The people that we've identified are the eyewitnesses to the first homicide. So their testimony is absolutely critical. And the state just doesn't have any necessity for that testimony to remain sealed. They can't.
Have you deposed those witnesses?
Not yet.
All right, state.
Or if you take the position that once the grand jury's matter is concluded, there's no longer a need to keep their testimony sealed, then we wouldn't have this body of law that's developed over the last 50 years, because in every one of those cases, the grand jury had concluded what they were doing, and they would have just been handing it out. The rule is the same. It has been the same. It's the same as in the federal courts, and that is that there has to be a showing of a particularized need. By the face of the motion, the defense is not even certain who testified in front of the grand jury. So what they may have said or what might be in there is pure speculation and surmise, which is exactly what the court has said. That's not enough. There is a case that come out of the 11th Circuit. It was originally Miller versus Wainwright. The U.S. Supreme Court took cert, sent it back for reconsideration, and reconsidered under Miller versus Duggar, which talks about that there is a lower standard for the court to order ex parte or in-camera review to make that determination. But again, there has to be some showing. In that case, you had two witnesses who had definitely changed their stories, and the court said, well, there's a possibility that raises the concern there's a third story, so we need to review it in camera to determine whether it meets that standard. But even an in-camera review isn't authorized when there's no showing whatsoever. If we take the depositions, if we have other evidence that witnesses have changed their story, there's conflicts, then we may be in a situation where we have to readdress it. But right now, it's pure speculation, and there's absolutely no basis to order even an in-camera review at this point.
Any reply?
Judge, a lot of that case law came up under circumstances in which civil cases, civil lawsuits were being pursued, and they wanted to try to get access to unrelated grand jury proceedings. But we're directing the court to issue an order in a case in which our client is facing the death penalty. And this is a specific indictment that indicts him. And the witnesses are specific witnesses that are going to testify against him. Of course, I don't know if they testified in a grand jury proceeding or not, because the grand jury proceeding is sealed. But it's most helpful. I mean, I could depose them, find out if they testified in the grand jury, then come back to the court, request that the court order the grand jury testimony, get the testimony, and then redepose them based on the testimony that they gave in the grand jury, or we could just cut to the chase. I mean, it doesn't matter to me if the court either orders it outright or reviews it in camera and makes a decision that way. But I think how much more particularized could a request get than the one that we're making, which is that these witnesses are going to be subject to cross-examination. I need to be able to cross-examine them, and I need to know everything that they've ever said before they take the stand. And if they've said anything in a grand jury indictment proceeding, then I should have access to that. If we don't have access to that, I don't know what kind of situation could be created in which a person would be entitled to get it. I mean, Mr. Loyd's on trial for his life here. So.
All right, I think, with all due respect, Mr. Mayor, that argument, if that argument holds sway, then in every case, once someone's indicted and some period of time goes by, that grand jury testimony could be ordered. So I'm going to deny the motion without prejudice to refile it if a particularized need materializes. I can imagine particularized needs. For example, I don't know that we'd ever get there, but if the state knows that a witness testified one way in front of the grand jury and changed his or her testimony in a deposition, they would be obligated to advise you of that. That could become a particularized need for you to get the grand jury testimony and have it in your possession. So at the current time, though, I don't think you've met the burden that's your burden, and so I'm going to deny the motion, as I said, without prejudice to refile it if a particularized need arises. There is a motion pertaining to a Smith & Wesson firearm. Do we want to discuss that or not?
Judge, I believe that they provided us recently after the filing of that motion a document indicating that about the firearm, the information they recovered on.
All right, Mr. Lanham. Okay.
Discovery. There are some things that may be litigated in the future on that issue.
All right.
Particularly that we have discovered that their investigator spoke to that witness and we have not been provided that information specifically.
With all due respect, Your Honor, they were provided that information specifically, so the court's information, defense asked for the original purchaser of the firearm. We obtained that information. We provided them with who bought it, when they bought it, where they bought it. Our investigator spoke to that witness, that person, just to make sure we had current information. The witness told him the history of the firearm. That was not a recorded statement. It's not a transcribed statement. There was no writing documents, and as we've already discussed, I'm under no obligation to have even provided that information. But thinking that it might speed things along and one less wild goose to chase, I provided that information voluntarily, telling them what the witness had told us. They want to take his deposition, they can take his deposition. There is no more documentation to give. Everything that exists, they've been given.
All right. At this point, I perceive that motion is moot, and something might materialize in the future about it, but it seems to me to be mooted. You know, when I presided over the business court, we adopted a meet and confer requirement, which now exists, I think, under the rules of civil procedure for discovery matters, so that the attorneys talk. I don't know that I've imposed that rule here, but I would ask you to comply with it, and I might enter an order that requires it, just because I think it could expedite things. We have the subpoena of Facebook records matter. Are you all willing to talk about, ready, I mean, not willing, but ready to talk about that one?
Judge, the only issue on it is the state has responded that our request is too broad. And my response to that is this, that my client, upon becoming friends with Ms. Dixon on Facebook, would have had access to everything that was on her Facebook page. So I don't know what all those things were. I don't know what information is in there about Ms. Dixon that could have affected the way my client thought about that situation, could have affected his frame of mind at the time. And so, I mean, if the evidence is irrelevant, it's irrelevant. I mean, I don't think we have any legitimate privacy concerns at this point. But I think I'm entitled to look through and see what kind of attitudes, what kind of facts about her life are represented in her Facebook postings. And whether those things are relevant to our case or not, I can't tell you. Because
you would think I wouldn't have to ask this question after 25 years on the bench and, you know, a decade or more of practice before that, but I've just forgotten this. For the defense to get a subpoena ducis tecum from our clerk in this circuit, as opposed to maybe other circuits that have administrative orders, do you need the court's permission, or can you just file a precipice and the clerk will give you a subpoena? And I should know the answer to that, and I just don't know it.
My understanding is that for non-party, that I would have to ask the court.
Okay. I wasn't 100% sure. You know, in civil cases, you can just file non-party production motions, but, all right, so you need to come to the court, ask for permission for the subpoena to be issued, then the subpoena gets issued. And then, and I'm talking about procedural issues now, I'll get to substance in a minute. If it's issued, it'll be served, you have to serve it in California. And I suspect at that point, Facebook will get fairly active in the litigation. That's what I anticipate will happen. And cite to this California Supreme Court case about what they have to do and not, or what they don't have to do. But they haven't been noticed of just the request, because that would be premature to be noticed now. Their notice will be, here's the subpoena, comply within the time period that the court allows. You did cite to 90, hold on a second. In the subpoena, it cites to 92.605. I looked at that statute last night. If we're really in that statute, I'm not 100% sure, although it seemed to me that that statute said the subpoena has to have bolded language and talks about it. The 17th Circuit had an administrative order. Apparently, maybe the practice, it seemed to me that the practice before the administrative order was defense attorneys could go to the clerk under press subpoena and get a subpoena ducis tecum, and the chief judge said, no, you can't. And then that administrative order was attacked and it was upheld. But at any rate.
That may be the case I'm thinking.
Okay. It seems to me at some point, I just don't know if this is the time, that probably Facebook, more than you, or maybe Facebook and you, are going to get into this whole Stored Communications Act analysis about the defendant's due process rights under the 14th Amendment and whether the postings or information is public information so that there's been an implied or express waiver, or whether it's limited to a narrower group than the entire world or all of the public, and then there's an analysis about there isn't an implied waiver. And I just imagine we're going to get down there, but right now I'll grant the subpoena ducis tecum. I really think what we're going to get to is these arguments probably from high-paid lawyers from Palo Alto, California, is what I suspect we're going to see eventually. So I don't know if you've provided me with an actual order. I see an attachment of the subpoena ducis tecum, so I might need an, if you have to get an order from me, I just need a proposed order that I'd like you to run by the state.
I'll do that, Your Honor.
All right.
Judge, there's just one issue I think the court needs to know. We haven't disclosed this to the state or the court, but I think this may be relevant in the future. we've come into possession of an Instagram photograph of the victim, Ms. Dixon, in possession of a firearm that was provided by independent witnesses to us, and we're following up on that. I can provide that to the state for further investigation.
Okay, well, my understanding of the discovery rules is if it's something you intend to offer at trial, you've got to provide them copies. Yeah.
We have a still photograph, but it's actually a video, Judge, so we're trying to obtain the video. You can see me for that issue.
Okay, very good. I'm not sure that I have to address this. I think I got a notice from you of your intent to call Ms. Ayala as a witness in penalty phase.
Yes.
If we get there, and if I understand the state's response, I think basically they're saying, well, we want to depose her if she's going to be a witness. And then I imagine it's whether her testimony is relevant or irrelevant would be something that gets argued down the road. Is that a fair assessment of where we are in that one?
Yes, Your Honor. As I pointed out, as I interpreted the document, it was not seeking any relief or order from the court or even from the state. It just simply an announcement that they intended to list her at some time, and my position is to find list her, and therefore I can take her deposition. I would anticipate, once I try to take her deposition, that she may resist that subpoena, and we will litigate that whole issue of whether she testifies or not at that point. But I think
Okay. All right, so you don't really, and I know there was some issue about her address. I mean, if you're going to call her as a witness, you got to list her, but you know how to find her, don't you? Okay, all right.
And as I also included in the same motion, if there are other witnesses they know right now they're going to call, I think they have an obligation to list them now so that I have some idea who they are.
I entered orders from the last hearing. I held on to one, and then I interlineated it. In that order, I just want to clarify, that order is about if the state attorney releases information to the press, you want to know about it. In the last hearing, I believe the court's position after conversation with Mr. Ridgway was most of these requests are public records requests, and they answer it through an email response, and I've asked them to order them ultimately to copy you so that if they respond to the media, they respond to you. And I've tried to state that in this order. And so that'll be entered in the record today, but it has some handwriting on it too.
Right, so I understand the court's position, and Mr. Ridgway has been complying with that since you were the court judge and providing that information.
Okay.
But the stuff that occurred prior to his compliance to the court order, the court is not going to allow me to have access to what they have sent and shared with the press.
Well,
They
I
have
did-
emails available through the communications, because my understanding is most of the stuff comes through communications and emails. He did mention there are sometimes he'll get a call, but I would like at least the emails that had occurred from the beginning of Mr. King's involvement in this case to the present with the press in regards to public records requests and information that is being disseminated.
All right, State.
The difficulty is twofold. First is our question what authority the court would have to order me to produce these documents. If they're public records because they have been supplied in discovery. So everything that was released was a redacted form of what the defense has already been provided, so they've got everything. Practical problem is that currently our system is to provide a link in an email that takes them to a server where they can download the material. So it's pretty straightforward. Although the links have a limited time frame, and once they expire, I may not be able to recreate it and find out exactly what it was. Early on in the process, a lot of the stuff was being put on CDs, and they had to come pick them up from us. We didn't keep copies of them. So I could not tell you what they got other than they got the discovery that had been sent in a redacted form. And reproducing it would be impossible.
Yeah, I'm not sure of my authority. I thought where we got last time was just as a matter of convenience, so we didn't spend a tremendous amount of time on it. You'd agreed that future email requests, you would just copy their email response.
Anything we're sending out to the media, we're sending a copy to Mr. Lemon.
If you got email requests prior to the date of that order, can you send, whether you send the response itself, but just here was the request for what we got, can you send that to Mr. Lenneman? Is that unmanageable or is that manageable?
I learned when I ask our IT people, is this possible, their answer is always yes, how much time he wants to spend doing it.
I see.
So I suspect that they could recreate them. How much time would be involved, because there's been multiple attorneys that may have handled them at different times. They come in from different sources, sometimes from private email accounts of the reporters involved, sometimes from accounts of the stations involved, so I'm not sure how a search would be constructed so that I could represent, here's all of them. A lot of times all it says is, can you send us the releases or the discovery or something, and it's not very specific as to what it is.
Why are you entitled to this in the first instance?
Well, Judge, let's cut to the chase on this situation. We have a very peculiar situation where a foreign, meaning outside this jurisdiction prosecutor was brought in this case. The local prosecutor was kicked off. At some point, my client complained publicly about being physically beaten up by the police. He lost his eye in the process. My understanding is that this prosecutor refused to go forward on that, or, because I'm not sure, I've asked for communications most recently through an email with Mr. Ridgway yesterday, or for some other reason decided to step back away from that investigation. The governor stepped in, appointed Phil Archer, who happens to be in his hometown, as the prosecutor now to investigate involving the FTLE investigation. Most recently, information has come out recently that there is a conflict in police testimony in regards to my client's cooperation or non-cooperation. And that's an ongoing investigation which is being conducted secretly, which I've asked for information from. So I have concerns that the way this information is being disseminated is targeted to interrupt due process and the proper judicial review by a jury by selectively putting out there what they want to put out there as opposed to putting out there everything that's requested. So the only way I can check that is have everything, all the requests that they claim, and look at that against what's been disseminated in the press through various television and newspaper reports. So I'm not saying that there's going to be a motion in regards to any kind of misconduct or improper influencing that Mr. King or his prosecutors were involved in, but I have certainly the right to check into it to see that they are doing things properly, because I have some concerns.
I want to make sure I understand this argument. So, am I summarizing it correctly? One of your arguments is that you believe the state attorney's office is without being requested, selectively releasing information somehow to the media to get out into the stream of commerce without records, public records requests coming to them from the media, that they're sort of just releasing things on their own?
I have some concerns about that, yes, sir.
And so if you got email requests, you'd be able to say, well, this was asked for, but I don't know if, X was asked for, I don't know if Y was asked for, how did Y get out into the public?
Correct.
And if they didn't keep these emails, how would you be able to address that?
Well, I think a start is to look at the emails that they did keep, Judge, and go from there. And I certainly can contact, and I'm not saying that they would disclose the information, I certainly can contact the various media agencies. And
good luck with that.
No, I get that, Judge. But guess what? We're in the middle of a triple homicide with the death penalty in play, where the prosecutor who had this, an African-American woman, was kicked off the case by the governor of the state of Florida and brought in one of the most successful persons who has been involved in the death penalty in the state, a successful prosecutor who's been a promoter of the death penalty in the state, Mr. King. So that's where we're at in reality now.
So since the last hearing going forward, Mr. Ridgway agreed that he would copy you on email requests from the media so that you'd be aware of it. I'm just going to ask you to talk to your IT people at this point and get back to me about how involved the search would be going backwards in time. I'm not sure I'm going to even grant the relief. Just give me some more info.
And just for the court's information and for the sake of the record, allegations of misconduct, bad faith, and all are part of Mr. Lindeman's stock and trade. He makes them frequently. They're scattered all through his motions. And I don't respond to them. I don't want the court or the record to think for a minute that in any way suggests that I'm acknowledging there's any truth to them. I will just state Mr. Lindeman says he doesn't know if we're releasing stuff voluntarily without there being a request. I do know, and I know that we're not. I also know that if the press asked me for something and I said, well, I'm not going to give you that, but I'll give you this, Mr. Lindeman wouldn't be here litigating the issue. Holland and Knight or some other law firm on behalf of the media would be here litigating this issue that I would ultimately lose. So I'll have our IT people see what we've got, what I can recover. It's not going to answer any of the questions or allegations that Mr. Lindeman makes, but whatever we've got, I'll see if we can get it together and I'll provide it to the court.
All right, so we'll revisit this again. I think that's it in terms of motions. Is there anything I'm missing?
Your Honor, the question is Ms. Ayala's. I know we addressed it, but is the court granting the motion to compel, or what's the resolution on that? Can I proceed on with subpoenaing her?
Well, I mean, I think the motion disclosing that she's going to be called as a witness would entitle you to depose her now.
But I can treat that as a...
I think that's notice. I don't know what else. I don't know how else to describe it.
All right.
Okay.
Thank you, Your Honor.
All right. What else? So I've contacted, help me with the judge's name, and is it Ocala?
No, it's Hernando.
Judge Toner. I just was drawing a blank for a moment. And I understand that your trial is on in April. Is that yours, Mr. Buxman? Is that yours and Mr. Loyd?
Yes.
Yeah. And again, I guess that's a fairly old case. I guess it's been reversed. It's back for trial. It's much older than this case. I didn't ask Judge Toner to do anything, just let me know if it appeared it was going to be continued or not. I didn't ask him to move anything. He said no. Apparently at the last status, the lawyers, all of the lawyers said we're ready to go, and we kind of want to go. Makes it appear to me that April might be out for scheduling for this matter, unless Mr. Lindeman's figured out how to be in two places at once, which is kind of hard to do. You want to talk about possible dates for the 2016 trial today? You want to wait? I can go either way. We can start the conversation. We might be able to come up with deadlines.
I don't know why we shouldn't at least start talking about it.
All right. I'm going to take about a 5-minute break. I have to check one matter that's not on my looking at May, if you want. But I need to confirm a particular at May, if you want. But I need to confirm a particular event. Recess, and I'll be back in. Recess, and I'll be back in. Recess, and I'll be back in.
Yeah.
Just to find out, you know what one it is. Martinez, it's not even worth us stopping by and talking to him just to find out what's going on. I think he's changed or at least maybe when we get back to Joe Cummings, JA. She might know exactly. You guys want the extension? Yeah. It's the mail, Martinez. I think that maybe. Let me check. I don't know which one. You don't have access on the phone to the court. I mean, I can call back downstairs and find out exactly. Six notes. I want to say it was a female judge because if I remember correctly, it was the one that she kept saying she. I don't know. Let's see his chamber's extension. That's his court. Martinez. Yeah, person is full credit.
Rise. Roll call to order.
All right, thanks, appreciate it. I'm proposing that we set the trial date in the 2016 case for May 6th. And so then we would work backwards in time for other deadlines. What's your response?
We can be ready then, Your Honor.
Okay, defense?
Judge, my request would be to set it in early July.
That's denied. So you open May 6th and the month of May pretty much?
I don't have a trial scheduled.
Okay, all right. So have the guilt phase witnesses been disclosed? I would think that that's happened.
It has, Your Honor, of course, in any case where things come along, dribble in as we go along, names are being provided from time to time. I know there's one lab report and one witness who's going to be a C witness that we're not going to call. That's going to be disclosed. I think the paperwork will be ready this afternoon or tomorrow. So there's that kind of odds and ends stuff, but the vast majority of it is disclosed.
So if, understanding that you have a continuing duty to disclose as if you learn of new witnesses, if I have a deadline of October 15th for the guilt phase witnesses, I imagine that doesn't present any issue for you.
No, that's something that arises that I don't know is in the works or I don't see.
What about penalty phase witnesses? October 31st, any problem with that?
From the defense or the
From
prosecution?
the state?
obviously, my guilt phase witnesses are going to depend on a large part to what the defense maybe they provided, rebuttal witnesses to theirs. Just off the top of my head, I think all of the guilt phase witnesses have already been disclosed. I mean, penalty phase witnesses have already been disclosed as part of the original discovery. I'll double check, but I don't see a problem with notifying.
All right, so guilt phase defense witnesses, October 31st.
You'll face state witnesses or defense?
Defense.
That's not recent.
All right, talk to me about that.
We haven't even done depositions. I filed probably 8 or 10 motions with the court in the last 30 to 45 days, getting experts appointed. They're reviewing the stuff, so we'll be setting depots in the near future. But for us to complete discovery, that's not only unreasonable, Judge, that's setting a period of time of 6.5 months where before trial that you're doing a cutoff. I mean, if any kind of cutoff, it should be in March or April.
Don't you have an obligation under the rules to disclose, once they've disclosed to you, your witnesses?
No, sir. We do not. We have not listed them. I don't have an obligation to disclose anybody I don't intend to call.
And maybe we're talking at cross purposes. Hold on for a second. Let me.
I think the court's looking for 3.220B, parent 1, parent A.
Right. That's what I was referring to. I mean, that's what we all know what the case law analysis is, but you have a 15-day deadline after you get their witnesses to give them your witnesses. That's what I'm talking about. So that's why I'm a little confused.
Well, I don't have any witnesses right now, Judge.
You don't have any fact witnesses?
No, sir.
Okay. Well, what's the problem if I establish a deadline?
Well, I'm going to object to it, and if I get a fact witness, the court will have to act accordingly. If I disclose a fact witness,
Then we'll have
because I have not been able to develop the witness or find the witness or had access to the witness or whatever the reason, which I would be clearly required to let the court know, then the court has to make a decision. It's like
Sure, but
exclusion is the last resort.
I understand that. But you also, under the rules of criminal procedure, have an obligation within 15 days of receiving the state's witnesses, if you know you have witnesses, to disclose them. And so down the road, if you said, Judge, I just didn't know about this witness, that's one analysis. If it was this witness was always available and I just never disclosed it to the state, pursuant to 3.220, then the analysis under the case law is a little different.
Well, I get it, Judge, but I can honestly tell you that I don't have any witnesses that at this point I'm going to
All right.
list.
But that's, I accept that.
That may change. The court knows I've hired.
I accept that, but you also know that if I give you a deadline, at some point we could have a discussion about when did you learn about this witness and why didn't you comply with the deadline. That's all. And right now we're speculating about where we would go from there, and I'm not sure that it's productive of our time. So I'm just establishing what the rule says as the deadline for your fact witnesses in the guilt phase, which is just a compliance with Rule 3.220. So I think it's a little bit of much ado about nothing. I'm going to set that date, and then we'll deal with it as we go. What I would like some input about is penalty phase witnesses. And you've disclosed one, and what deadline do you think is fair for your disclosure of penalty phase witnesses?
"30 days before trial, early April."
State, is that manageable for you?
I don't think that that's a problem per se. and I may be anticipating problems that won't arise, but as we've discussed, Mr. Linneman is going to be in trial in Hernando County beginning in early April, and if I'm trying to set depositions during April of these penalty phase witnesses, and he's in trial scheduling, I mean, I'm going to have to take depositions with Mr. Marrero there and not Mr. Linneman, which is fine by me, but I just don't want to run into the issue of they're saying, hey, you can't take their depots because Mr. Linneman's not available.
All right, April 1st for that. What about defense witnesses who may seek to establish mental mitigation in the penalty phase?
How about March 1st?
All right. I'm borrowing a little bit from Judge Tynan's order where he had deadlines for depositions of witnesses. And I'm thinking that's probably a prudent thing to do. And so let's talk about deadlines. He had listed current and former law enforcement officers or law enforcement employees and all other guilt phase witnesses. What are your thoughts about that breakdown?
Well, so here's the problem, Judge. I foresee in the very near future beginning to substantially litigate the issue of this open investigation involving the Florida Department of Law Enforcement and the beating of my client, because it's a relevant issue in this particular case that portrays my client as someone who is resisting as opposed to someone who is willing to give up. And that goes in turn directly to the issue which occurred with Master Sergeant Clayton, where we believe we're going to show a very heightened state of mind that my client was in the period of time leading up to the shooting and the confrontation with Clayton. So that's a relevant issue. That's a big secret on their part. They don't want to share it, Judge. I anticipate that they're going to fight me on that issue. So I'm going to need all the documents, all the statements, every part of that investigation to talk to that group of officers who were involved in the arrest and takedown of my client. And that's extremely relevant to their Williams rule now, where they have listed on their 2016 discovery that every witness that's listed on the 2017 discovery is part of the 2016 discovery. Even if they want to call 6 or 8 as they claimed in their Williams rule response, they still listed everyone, and so I have an absolute right to depose everyone on both cases before we go to trial.
Right. All right. State.
Just so the record's clear, we haven't explained this to the court. I think I addressed it in one of my pleadings, is that when Mr. Loyd made his complaint of criminal activity involving officers toward him, we requested the governor appoint another state attorney to oversee that because of the obvious issues of Mr. Loyd being compelled to give statements in that investigation and the immunity issues it would cause. And so with the full knowledge of the defense, we did that in order to comply with the requirements of Castigar versus the United States to protect Mr. Loyd's right against this self-incrimination. If Mr. Loyd wants to waive his Fifth and Sixth Amendment rights as to any statement he made in the course of that investigation, I will use every resource at my available to get everything in that case and provide it to Mr. Linneman if he wants it. I've disclosed it to him. He knows who has it. He knows that it's FDLE in Mr. Archer's office. He can take whatever actions he wants to get it from them. Nobody's hiding anything. And questioning how something that happened weeks later in the arrest of Mr. Loyd has any relevance to the murder of Sergeant Clayton, perhaps that become revealed later. But if I don't understand what all this has to do with depositions, I would point out, Mr. Linneman says he's got hundreds of depots to take. And on July 17th, when we had the hearing here where Mr. Linneman appeared by video and the court questioned him about his ability to get ready after saying that he had been sort of shadowing the case and was familiar with it generally. He made the statement that only about 15% of the depositions would really be important and really needed to be taken as part of his statement, where he didn't say he'd be ready in January, but he said he would, said that there was a distinct possibility he would be, and that he could comfortably move forward in an attempt to be ready in January. And now today he's telling us he's got to do hundreds of depositions and can't possibly be ready. So whatever the court sets as far as discovery cutoffs, we'll be there. We'll do what we're obliged to do. And Mr. Linneman wants to get this information from the FDLE or Mr. Archer's office, file the appropriate motions. I'm sure they'll be here and court can order whatever they're entitled to.
First of all, Judge, if I can respond briefly. I didn't say hundreds. I don't know what room Mr. Ridgway was in. I directed my argument towards two issues. Number one, the officers who were involved in this particular takedown, specifically the one who kicked my client in the eye. I want all the statements from those officers so I can take their depots.
Statements in...
All the officers that were involved in the takedown. There's probably a dozen.
Right. Well, have they filed... so in the takedown, which was subsequent to this, so do you have were there statements pertaining to that?
I'm talking about the statements from the FDLE. I am sure they gave statements to the prosecutor and to the FDLE in the investigation, or they didn't. Maybe they decided to vote, Judge.
All right, so...
That's important information I need to know.
Let me slow down for a minute. And that's relevant to the first case because of the Williams rule notice?
Everything is relevant to the first case because of two reasons. Number one, they listed everybody in the second case.
Right.
So therefore, technically, even though the court rules or limits what information is available, they could call one of those witnesses for a myriad of reasons. That's number one. Number two, because they listed specifically in the discovery all those witnesses, Judge, which I didn't know when I got involved in July of 2017. I didn't know that they had a provision in the discovery of the 2016 case listing all those witnesses. They did that, and so therefore I'm entitled to take their depositions. So I'm not saying I can't be ready. I'm telling the court is going to, he wants to put up this invisible wall and say, Mr. Archer is over here, and we don't see or hear what's going on, even though it's part of his case. He's distancing himself from the responsibility that he, as the prosecutor, to provide me this information, claiming that because another prosecutor was appointed by the governor, if I waive my client's statement, that he's willing to give everything. That's ridiculous, Judge. He's required to give you this stuff.
Yeah, I didn't really understand that to be his position anyway. What I understood Mr. Ridgway to say is to avoid a further conflict, Mr. Archer's been appointed, but that he, to the extent that he has any sway with them, would say, get those reports to Mr. Linneman so that he could use them. And so I just don't, your interpretation of his statement is at odds with my interpretation of his statement.
Judge, he just said, Judge, excuse me, he just said that if my client waives his right on the statement that he gave as part of that investigation, then he would go out of his way. He codified that, Judge.
Yeah,
you go back and read the court reporter's statement. That's what he said.
Okay, calm down for a second. I think we're going down a rabbit hole that's a little bit counterproductive to really what I'm trying to address, which is deadlines. And I think what I'm going to do is this. I've got a trial date. I'm going to back up from that trial date certain deadlines. We've had this conversation before you were in it with Mr. Weed and Mr. Marrero. I'll send out a proposed pretrial scheduling and discovery order, and then I'll let you all respond to that. Maybe we'll have another hearing where we just go through deadlines. Some of them I think you'll just agree with, and then we can discuss the ones that that seem problematic, because I really do think we're going down a rabbit hole we don't have to go down right now. I understand in part your argument. Not sure I understand it fully. Maybe that's my limitation. And do you have any sense of where the Archer investigation is?
The only, I mean, Your Honor, I contacted their office yesterday and requested a result. We went to the hearing in June, I believe it was. I went with Mr. Loyd, where he was questioned by agents from the Florida Department of Law Enforcement about what occurred, and that's all I know about it. I don't know any other part of their investigation. They haven't contacted me since or told me anything about if it's concluded. I mean, it's hard to imagine it would have concluded by now, but in any case, they're not letting me know.
Yeah, I'm going to propose deadlines. I'm still processing, and I may get a copy of the transcript of this because I want to understand your statements about the relevance of his arrest as it relates back through to this first case. And I'm struggling processing that right now, so I want to give it some thought. I may ask you to elucidate on that down the road. I'll take a look at what you said on the record. But what I really want to do is get these deadlines. We have a trial date. I'll back up to a pre-trial. I'll back up to certain deadlines. I'll send it to you, and then we'll go from there because I just think we're kind of going into places we don't need to right now. The other thing I just want to emphasize, but I know that this is very important litigation, but I also know that you all are officers of the court. Personal attacks are distasteful to me and counterproductive, and I want those to cease. And I think you all are experienced trial lawyers and can make your points to me without getting too personal about things. So I'm going to propose this order, and then we'll go from there. Anything that we need to talk about before we recess then?
Just one brief footnote to the whole issue, just so it's clear, the names of the officers that were involved in what Mr. Lemon described as the takedown have been provided in my response to discovery, and the reports they authored at the time have also been supplied.
Okay, so the only reports would be this FDLE investigation.
Whatever they're doing, I don't have
those reports, which would, I presume, be the product of the FDLE investigators. In other words, do you anticipate that the law enforcement officers involved in the takedown would be providing further written statements or just being interviewed?
Well, I'll give you an example, Judge. I've gone through most of the discovery, if not all the discovery Mr. Ridgeway gave me. I don't recall reading a report where an officer said that Mr. Loyd was cooperating as he was crawling out on his belly. I only read about it the other day or saw it on the television.
Where was it being
reported? So apparently there was a statement made in the investigation at some point in regards to this cooperation that I have not been provided.
That he was cooperating in what, man?
That my client was cooperating.
In what?
In the takedown. When he was coming out of the house, he was crawling on his stomach.
All right.
What we do know is we see a helicopter hovering over them, police helicopter, filming it, and then my client...
All right, I just missed, I thought you, when you said cooperating, I thought you were talking about the investigation itself, cooperating in the investigation. I'm still having a little difficulty processing the relevance of all this. Again, that could be my limitation, but I'm struggling with it, and I'm not sure it's productive to get into all this today because I'm just trying to set deadlines for discovery and trial, and we may visit these issues down the road, but I don't know what it's accomplishing today.
Just for Mr. Levin's elicitation, that report was based upon the police report of Deputy Sheriff Atworth, whose name has been provided, and that report was provided in the original group of discovery back at the very beginning of this case.
All right, well, again...
When I can't locate it, I'll be happy to send another one.
I'll propose, we have that deadline. I've got some preliminary deadlines. I'm going to propose other deadlines. I'll send it out to you. You all can take a look at it. You can talk with one another, and then we'll have a meeting if there are controversial deadlines. But I want to get the thing scheduled. And I think that's it for today. Anything further?
No, sir.
Okay, great. We're in recess. Appreciate it.
All right.